everyone. Thank you very much for joining us. We will get started. My name is Jie Huang. I am a senior associate at Scott Legal PC. And today we are going to spend some time talking about the E-2 visa requirements and answer some of the common questions that come up when preparing an E-2 visa file. Our firm has seen all types and varieties of unique entrepreneurial projects for E-2 visas, and we will be focusing on strategies for the more risky cases with lower investment amounts. So a few things before we get started. Some of you may know that the firm was founded on an E-2 visa 10 years ago. Actually, our founder, Ian Scott, is in the US currently on an E-2 visa. So, and this was successfully renewed multiple times. So we know exactly what you are going through. Scott Legal is a full service immigration law firm. So we do process a variety of family-based, employment-based, and various types of immigrant visas. But we do focus primarily on E-2 visas, and we have processed hundreds of E-2 visas, and we typically process many E-2 visas that are higher risk with lower investment amounts. We have processed at consulates around the world, but our primary two consulates are Toronto and London. We will be continuing these webinar series. We will be offering at least 2 webinars a month on different immigration law topics, so please feel free to follow us. At the end of this webinar, we will be sending out a few things. First, we will send you a PowerPoint that we will be using in this presentation. We will also be sending you a comprehensive E-2 visa guide that you can use as a reference. We will also send you a link where you can sign up for the additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. And this webinar will also be available on YouTube. And we encourage you to subscribe to our YouTube channel and hit the notification button, as we do regularly upload a variety of immigration videos. Finally, we will send you a link where you can set up a consultation with one of our lawyers if you wish to discuss your case further. So today, we are very lucky to have Dustin Saldarriaga, a senior associate at the firm, who has a wealth of E-2 visa experience, who will be answering some of the most common questions regarding the E-2 visa, especially as it relates to the more risky or challenging cases. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, let us move into the presentation. So Dustin, maybe we can start. Who can apply for an E-2 visa?
Absolutely. So thank you, GA. Thank you all for being here and for your patience as we sorted through some technology issues at the start. So basically, when looking at who can apply for an E-2 visa, an E-2 visa is what's called a treaty investor visa. And basically what that means is that the United States needs to have a treaty agreement with your country of nationality. Your country of nationality is simply a country that you have a passport from. So if you are a dual citizen, it's only necessary for you to have the nationality of one E-2 treaty country. There are dozens of E-2 treaty countries. They are listed on the US Department of State's website. If you Google E-2 treaty countries, Department of State, you will find the list of countries. They do occasionally change, though not frequently. Recently, Portugal was added as an E-2 treaty country. Israel was also added not long ago, as well as New Zealand. And occasionally companies fall off of the list. But if you're considering an E-2 treaty visa, then step 1 would be to figure out if you have the required nationality. If you do have the required nationality, the E-2 visa really is one of the best options for a foreign national to come to the US to develop and direct a business. And that could mean either starting a business, or it could mean purchasing a business, or even starting a franchise. So it is certainly worth considering, and we'll talk more about what makes it so attractive during this presentation. So why don't I run through the E-2 requirements real quick so that everyone's on the same page. What I was just talking about is in terms of having the nationality of an E-2 treaty country, we refer to as the nationality requirement. But there are a number of other requirements. You see them on your screen. The second requirement is that as an E2 investor applicant, you must own at least 50% of the E2 business. And when I say the E2 business, I mean the company that's in the United States that will be the basis of your E2 visa application. You are essentially telling the government that you want to come to the US to either start that company or to grow that company, ideally both, or for an existing company to simply grow it, and ultimately to employ US workers. So you need to own at least 50% of the E2 company. That means you can have a co-owner. There can be 50% co-owners. As long as each one owns 50%, they would both be eligible for E2 investor visas based on the ownership requirement. And just to take a quick example, let's say that there is a national of Canada and a national of Germany. They each own 50% of a US company that they want to be the basis of their E2 visa applications. They could each apply for an E2 investor visa, and that would give the company dual nationality. It would then have Canadian nationality as well as German nationality. Both of those countries are E2 treaty countries. And that would allow them to employ E2 employees from either Canada or Germany. And of course, those E2 employees would need to qualify. They'd have to apply for E2 employee visas. But as long as the applicant can show that they qualify, then nationals of Canada or Germany could be eligible for that. Again, that is if the business is equally owned 50-50 by two nationals of E2 treaty countries. Let's say that the national of Canada owns 50% of the company, and the other 50% is owned by a US citizen or a lawful permanent resident of the United States. The Canadian would still be eligible, but the US citizen or the lawful permanent resident of the US would not be eligible. They simply cannot apply for an E2 visa, even if the lawful permanent resident is a citizen, say, of Canada. Becoming a lawful permanent resident makes you ineligible for an E2 visa. And finally, to take a simple example, let's say that the Canadian owns more than 50%. They own, let's say, 80%. The company would then have Canadian nationality and would then only be eligible to employ Canadians as E2 employees. And again, each employee would have to satisfy the requirements for an E2 employee visa. The third requirement that you see on the screen is that the applicant must make a substantial investment. This is actually the requirement that we get the most questions about, because what it comes down to is, how much money do I need to invest in the business to be eligible? Unfortunately, the government, or maybe fortunately, the government does not publish a set dollar value. The government does not say if you invest $500,000 into a business, you meet this requirement. Instead, what they say is that the test that will be applied is what's called the proportionality test. And that means that if the business requires less money to get started, such as a consulting firm or a small software company, say, then the government wants to see 100% of that amount invested into the business. If the company is more expensive, is more capital intensive, such as a manufacturing plant, for example, then the government is okay seeing a percentage, a fraction of that total investment amount, total required investment amount being spent before the application submitted. Again, that's still a very vague kind of guideline. So what we see in practice is that any application with an investment amount of under $100,000, we consider to be risky. That does not mean likely to be denied. Again, as GA said at the start of this presentation, we actually handle many E2 visa applications with investment amounts in the $50,000 to $60,000 range, so below that $100,000 amount that I mentioned before. But for a risky case, we do have to take into account other aspects of the application and really strengthen those other aspects so that the low investment amount does not result in a denial. And this presentation really will focus on those riskier cases. All right, in addition to that investment amount, the source of the funds that are invested into the business need to have been acquired from a lawful and legitimate source. Fortunately, this can be almost anything, as long as it's legal. It can be income from work, can be a gift, can be a loan, it can be proceeds from the sale of a home or an apartment or tangible property. And it can even be, say, credit cards, an unsecured loan. The limitations on the source of funds: you cannot use a loan that is secured by the E-2 business or its assets. You also cannot use funds that are retained earnings of the E-2 business. So let's say that while you were in the US on a student visa, an F1 visa, you started a business, and you have $100,000 of retained earnings in that business, and now you want to apply for an E-2 visa based on that business. You would not be able to simply use those retained earnings and say, you know, here are the funds, they're in my business bank account, therefore I qualify. You would have to distribute those funds to the applicant. You would have to show tax returns and records that prove that the funds were actually distributed to the applicant. And then the applicant would need to show that they have committed those funds to the business. So the applicant needs to have personal possession of the funds if they are coming from the business's earnings. Typical expenditures, we'll talk a bit more about that, so I won't mention it now. And finally, on that requirement, substantial investment, we'll also talk more about how you can, as I said, purchase a business. Usually the fair market value of the business would satisfy the substantial investment amount. The business cannot be marginal. This is a key requirement, and basically what it means is that the business needs to employ US workers. The government's explicit that an E-2 business cannot be solely to support the E-2 applicant and their family. So what we usually say is the applicant should aim to employ at least 3 full-time equivalent US workers within 5 years of starting operations. More is of course better, but usually the government is satisfied with 3 full-time equivalent workers within a 5-year time frame. If you can employ earlier, that makes for a stronger application. If you can show you're employing people before you apply, that is excellent. It's not required, but it is certainly a strength in an application. We'll talk more about that a bit later. The business must be real and operating. This does not mean that it needs to be generating income before you apply. What it does mean is that the business needs to exist. So you need to have established the business legally. You also need to have committed the funds that we mentioned before to the business and purchased everything that's necessary for the business to start operations. Basically, the way to think about this requirement is if you are at the consulate in front of the officer in your interview, you want to be able to tell the officer that the only thing that needs to happen for this business to start operating is for them to issue the visa to you. All licenses are lined up. All money has been spent on the office space, on office supplies. If you need an employee, they have been hired. Everything is in line for you to get the visa, get on a plane, get here, and start running the business. You also, one of the 6th requirement for an E-2 visa is that the applicant will solely develop and direct the E-2 business. So what that means is, first of all, that the applicant needs to be qualified to run the business, develop and direct the business. That can be showing in the application your resume that shows professional experience. Could be showing that you have an educational background that qualifies you to do this. And importantly, if you're applying, especially within the US, at USCIS, if you're applying for a change of status, consulates tend not to focus as much on this, but USCIS does. You do need to make it clear that your role as an E-2 investor will be to develop and direct the business, in contrast to providing the product or service that the business offers. So for example, if you are trying to start an accounting firm, it's very important if you're applying through USCIS to show that you employ an accountant who will be providing accounting services to clients. Your role is to build the accounting firm, to network, to advertise, to market, to invest in the company. to really build it and hire more accountants. But your job is not to be the accountant for the firm. And again, that tends to be less of an issue at consulates, more of an issue with USCIS. And finally, the E-2 visa is a non-immigrant visa, meaning that you need to intend to leave the United States at the end of the validity of the E-2 visa. The E-2 visa does not directly lead to a green card. And, you know, you can apply for a green card while you're in the US on an E-2 visa, but you need an independent basis, whether that is a family sponsor or an employer, even self petitioning for yourself. But the E-2 visa is not a stepping stone to a green card and does not necessarily improve your chances of getting a green card. So that's important to understand. At consulates, this usually doesn't play too much of an issue, present too much of an issue. Consulates are actually given guidance that's clear that the applicant does not actually need to maintain a home outside the US. So the E-2 visa actually has fairly low requirements to show your ties to your home country, but still you should be prepared to show that you do have ties outside the United States through bank accounts, etc. Maybe you have a mortgage, maybe you have an apartment that, you know, encourage you to leave the US at the end of your visa. So that's a quick overview of the requirements. GA, I don't know if there were any questions that rolled in or any questions that would be helpful at this point.
Yeah, thanks for asking. So we do have questions regarding the requirements. So one of them is, I believe, regarding the E-2 employee visa. So question from Louisa: can an applicant own 100% of the company, but the applicant, I guess the owner, is not coming to the USA, but instead request a visa for another co-national to work in the E-2 entity?
Yes, you can do that. That's a great question. So basically, the requirement is that the E-2 investor, if there is an E-2 investor, if they are in the US, if they visit the US, they need to be in the US in E-2 status. But if the E-2 investor, and I'm saying that term, you know, assuming that they actually don't have a visa in this example, if the person who would be the E-2 investor never needs to come to the US, they obviously don't need a visa. They can remain outside the US and essentially apply for the business to be characterized as an E-2 business, and the business can then support E-2 employees. So, you know, we do see this. These applications can be approved. Essentially, what you would need to show when the E-2 employee applies for the visa, and that would be, depending on the consulate, some consulates require that you actually register the business first. Other consulates say when the E-2 employee applies, they need to bring the materials that the E-2 investor would need to bring to prove that the business qualifies. But essentially, the employee would show that the business is actually owned by nationals of that treaty country. So yes, the answer is you can do that.
All right, let's see. And then there is another question regarding, I guess as a follow-up regarding the fact pattern that we just discussed, the E-2 employee should be from the treaty country. And I believe the answer is yes.
Yes, that's correct. The E-2 employee must be from the treaty country. So
right.
To take one of our examples, if the company is 80% owned by a Canadian, then only Canadians would be eligible for the E-2 employee visa.
Right. Great. Let's see. Could we have a manager citizen of the US running the company while the candidate is submitting his application, and put in a clause that the applicant owner of the company will be the manager as soon as he receives the visa? And I believe that relates to the question of having employees in the US already before the investor gets the visa and arrives in the US. And is that a common situation? And what are your thoughts on this scenario?
I think this is actually kind of an ideal. This is what we would probably recommend. If you are either outside the US or you're in the US, but you do not have work authorization, what we would recommend is that you have a US citizen or someone who's eligible to work in the US to actually be your first employee. And they would be responsible for the day-to-day, growing the business. That is helpful on multiple fronts, actually. First of all, it helps the business grow. So you have more to show the consulate that, look, I already have, contracts in place. I already have letters of interest from prospective clients or suppliers. It allows you to show, in terms of the real and operating requirement, which I'll put back up on the screen, the real and operating requirement that you've taken steps in that direction. It also helps you on the marginality requirement because you can show the consulate that you have already started employing someone. And that is the strongest evidence that this is a business that will employ US workers if you're already doing it. So great question. And that is exactly what we would recommend. If at all possible, try to hire a US worker that can start getting the business off the ground.
Thanks so much, Dustin. And so just another question regarding the eligibility of nationality. So maybe we can answer that and then move on to the next slide. So this person, they are from a treaty country. Their brother is a US citizen. So can himself and his brother own 50-50 and the person who is the treaty country national apply for the E-2 visa?
The answer is yes, as long as you the non-US citizen does not have dual nationality, you can certainly be 50% owner. The requirement is ownership equal to or greater than 50%. So as long as you are not a US citizen or lawful permanent resident, and you do have at least 50% ownership and you have nationality of a treaty country, you would satisfy the nationality requirement.
Thank you for the clarification. And now let's move on to the next slide.
Sure. So this slide just gets into a few more details on what we were talking about before. We already talked about this first bullet, which goes over a couple of the requirements, the nationality requirement and the develop and direct requirement. Options for obtaining an E-2 visa. We also talked about how you can either start a startup or purchase an existing business. And again, we will go into those a little bit more later. Third point, we did discuss how there needs to be a treaty between the US and the country of your nationality. And again, there are dozens of these countries. They span Europe, Africa, Asia, Latin America, and the Middle East. Do check the Department of State website. The last bullet we did not touch on, the E-2 visa ranges in validity. And really, this is called reciprocity. Reciprocity is basically an agreement between the US and the other country in terms of the amount of time to grant the visa. So E-2 visas range from 3 months up to a maximum of 5 years. And it is dependent on your country of nationality. So what you can do, again, you can go to Google and you would Google reciprocity E-2 visa, and the Department of State has a website that you would first click on your country of nationality, say Canada, and then you would click on E for E-2, and it will show you actually how long you can be issued the E-2 visa. Now, the important thing to keep in mind for excuse me, visa validity is that it's different from status. What that means is an E-2 visa only gives you the ability to ask for admission into the United States. So as long as your visa is valid, even if it's the last day that your visa is valid, you're basically allowed to ask a border officer, please let me into the US, and typically they will allow you to if you have a valid visa. As soon as you enter the US, you're given status. And usually with an E-2 visa, you're given 2 years of status on each entry. So to take an extreme example, let's say you have a 5-year E-2 visa. Let's say that 4 years and 364 days pass. On the last day that that visa is valid, theoretically, you could enter the US and you would be given 2 years of E-2 status. Now, status does not let you travel. It only lets you remain in the US. So you would have to leave the US within those 2 years. And the date is actually stated on your I-94 form, which is given on each entry to the US. But as long as you're remaining in the US, you would typically be given 2 years. So what most people do is that they're granted the visa, they enter the US, they have 2 years of status. When those 2 years are up, they'll usually travel. They'll leave, go home. It can be a brief trip. It doesn't have to be long. Come back in and they're given another 2 years. And they'll do that until they reach the end of their E-2 validity period, at the end of those 5 years. When that date rolls around, they'll reach out to us or their attorney, file the application at the consulate, and apply for a renewed visa, get another 5 years, or whatever the validity period is of the visa. E-2 visas can be renewed indefinitely, so they really are an excellent option for the foreign national that wants to build a business in the US. GA, were there any questions, or I can move on to the investment amount, if that sounds all right?
Yeah, let's move on, because there are some questions about, the employee, the marginality requirement, which we will later get on, and there is also the change of status related question. But we actually did have one question just pop up just regarding the point that you made regarding reciprocity, Dustin. So one person is wondering, okay, so how does it work if somebody gets a 3-month visa, E-2 visa granted, right? So how does that work?
Yeah, that's a good question. So 3-month visas are frustrating when you have the nationality of one of those countries. Fortunately, they're rare. Not many countries. Most countries have much longer validity periods. If you are national of a 3-month visa country, basically you would have 3 months to enter the US, and upon entry you have 2 years here. If you are someone who likes to travel frequently, then unfortunately it does mean you would need to apply to renew your visa in your home country. However, if you don't need to go home often, what you can do is at the end of your 2 years of status in the US, you can apply to extend your status domestically. You don't have to leave. You can stay in the US, and essentially you would ask USCIS to extend your E-2 status another 2 years. And you can continue to do that as well, as long as you and the company remain eligible for the E-2 visa. So in general, especially before COVID, we didn't see many E-2 applications with USCIS. And when I say USCIS, that's US Citizenship and Immigration Services. It's the agency located inside the US that is responsible for extending status or changing your status. So we didn't see many E-2 applications going to USCIS before COVID. When COVID hit, it became much more difficult to travel, of course. So we saw more people applying to extend or change their status through USCIS. And one of the groups, though, that has always been more likely to extend their status domestically is people who are nationals of these 3-month visa countries.
Thanks, Dustin. And maybe now that we started talking about the change of status option, we can also answer this other question that came up. Someone is asking, so they would like to change status to E-2, right? What about the dependents of the applicant? So if the principal applicant changes status to E-2, how could the principal applicant's wife and children get their visa from a foreign consulate?
Yeah, so the question, I'm assuming that the spouse and children are abroad. They're not inside the US with the principal. So if that's the case, they are eligible to apply for E-2 dependent visas at the consulate. They would essentially first, you as the principal would apply for a change of status from, say, B1 to E-2. Once you have that approval, you would make sure that your spouse and children have a copy of the approval. They would then apply on that basis for the E-2 dependent visa at the consulate abroad. So there is specific guidance on this in the consulate's, it's called the FAM, Foreign Affairs Manual. Not all consulates may be aware of the guidance. It is somewhat new to make it explicit. But the law is, and the rule is that they should grant status to the spouse and children. Of course, if they are also in the US, you can apply for a change of status for them as well, domestically through USCIS. And the last thing I'll say on this, since we're talking about spouse and children, is that the E-2 dependent visa for children allows them to study in the US. They cannot work. The E-2 dependent visa for a spouse, though, gives automatic work authorization, and that is new as of January, I think January 2022, so
Right.
just over a year ago, that as soon as an E-2 dependent spouse enters the US, assuming that they are given the correct status, they are able to work immediately, which is a wonderful thing. And they can
Right.
also study.
Great. And one last logistical process related questions before we move on to the investment amount considerations would be, does an E-2 visa holder, when they're renewing their visa, do they have to do it at their home country?
Very good question. The general recommendation is that you should. And the reason is that usually the way consulates work is once the business is approved, the business is essentially, it's registered. And so many consulates do have kind of a registration database. If you're approved in Toronto, for example, you'll immediately get an email that says your company, named Your Company LLC, is registered, and the registration expires, 5 years from now, or whenever it is. So it can streamline the process if you apply at the consulate, because they may already have records about your prior approval and your business. That being said, there are some cases where it just doesn't make sense for you to renew at your home country. Your home country, there may be current events that make it hard to return. It may be a uniquely difficult consulate, in which case, technically you can apply at a different consulate. One of the consulates that we see most frequently applied to is Toronto. Toronto tends to be open to applicants who are residing in the US, and residing does not mean permanent residence. It means that you're in the US on a valid visa. At least that's one way to interpret it. So if you were looking for an alternative consulate to apply to, Toronto may be a good option. And the last thing I'll say on this is you tend to be able to go to those consulates that you have ties to, the host country. So let's say that your E-2 visa was initially granted in Germany, but you're also a national of the United Kingdom. You could make a good argument that you want to apply in the UK. That's not necessarily strategically a good thing to do, but again, we would recommend that you apply at the same consulate, but there are circumstances where you would not need to.
All right. Thank you so much, Dustin. I think we can go on to the next slide.
Perfect. So I touched on a lot of this before regarding the investment amount. How much of an investment is enough? Government doesn't have a set dollar amount. It depends on the type of business. And really, the government's looking for two things when they look at the investment amount. The first is, has the applicant committed enough money to convince the consular officer or USCIS that they're actually committed to the business, right? The amount of money invested is really kind of a litmus test for the government to say, okay, they've put $100,000 on the line. They're serious about this. Excuse me. So that's the first thing. The second thing is that the government is looking for sufficient funds to have been invested in the business so that the business will actually be successful. So that's what gets at, what we typically include in an application is actually a spreadsheet that lists out every single expenditure on the business, along with a reference where the officer can find a copy of the invoice, the receipt, and the proof of payment. So what we do in that spreadsheet is we have kind of a master page that lists out every category of expenditure. Office space, here's how much we've spent. Company formation fees, here's how much we've spent. Inventory, here's how much we've spent. Office expenditures, here's how much. Employee payments, so that the officer can look at that one page and see, wow, they have spent money on office space, on everything that's needed for, again, the business to be operational as soon as the visa is issued. So if there are other items that you can purchase in order to make the business operational, if there's certain things that are missing, those things do need to be purchased. So the investment amount should be enough for that business to really get off the ground. Now, again, if it's a more valuable business that requires, I would say upwards of $1 million for it to be started, the government may be open to the argument that, we have spent a fraction of this amount of $1 million required. We've spent 600,000. They might buy that argument. That argument, though, will not be accepted for businesses that are less than, say, $200,000 to start. So if you are starting a consulting firm or, a software company that requires anything less than 200,000, I would say you really need to have spent everything that's needed to start the business. You can also include in your application additional evidence that shows that your investment amount is substantial, such as a letter from a certified public accountant in which they say, I've reviewed the materials and the amount invested, and based on my expertise, this is the typical amount that's sufficient to start this business. That can be beneficial. You can also include business articles or articles from trade publications that talk about the amount to start that type of business. The example I like to use is I had a client who was starting a tattoo parlor, and they invested a certain amount of money into the business. And we had a great conversation where I learned that there are trade publications that talk about how to start tattoo parlors and the cost of starting a tattoo parlor. We included those articles in the application to show, hey, this is how much is typically required, and our client has spent more than that amount. Finally, if you are purchasing a business rather than starting a business, as long as the business is purchased on the open market, meaning that anyone can put an offer on it, the value of purchasing that business is usually substantial in the eyes of the government. And you would want to include evidence, that the business was advertised on the open market and that you paid the fair market value for it. And if there's any doubt on that, again, you can get a letter from a CPA to speak to the valuation of the business. So we'll switch gears now to talk about strategies to deal with a low investment amount. And again, this really is something that our firm navigates frequently. And so, what we would always say is there are specific dollar amounts that raise flags for us. Anything under 100,000, we know we are going to need to make sure other aspects of this application are strong. When you get below $40,000, $30,000, $20,000 investment, you really do start getting into an area where you may be facing a denial based on the investment amount alone. It does depend on the consulate, but let's talk a little more about that. So when you have a low investment amount, the first thing I want to say is low investment amount means the amount committed to the business. It means the amount that has actually been spent on office space, on inventory, on office supplies. It is not the amount that is sitting in the business bank account. The government does not consider working capital, meaning the amount that's just in the business bank account, as contributing to the overall investment amount. So if you have $5 million and you've put it in a business bank account, you will not be approved for an E-2 visa if that's all the funds you have. The government, again, wants to see that you've spent the money that's needed to start the business. So working capital does not satisfy the substantial investment requirement. Working capital can strengthen an application that already has satisfied the substantial investment requirement. So as an example, let's say you're starting a consulting firm. You've spent $100,000 on the business, on all the things you need, office space, an employee, etc. And you have $70,000 sitting in the bank account. You shouldn't ignore that $70,000. You should make it clear to the government that you do have additional funds that are reserved as working capital, and that's the money you're going to use to actually expand the business, or to increase marketing, or to hire workers going forward. So don't ignore working capital, but also don't see working capital as a substitute for a committed investment. So on this slide, we're talking about committed investment. If you have a low investment amount, again, under $100,000, though in general, again, it depends on the type of business, but in general, $100,000 or less. The first question is, what are the other strengths of the application? Has, for example, the business already hired an employee? If they have, that's a significant strength, because it shows that even with a low investment amount, this is a business that can sustain a worker. You might already be able to show that the business is real and operating, and you might emphasize that. So, for example, you already have contracts with clients or suppliers. You already have letters from people who want to do business with your company. You may have a letter from the local chamber of commerce that says this is a business that's going to benefit our community. You might also have bank statements that show that this is a business that's already generating revenue. So what all of that says to the officer is, even though the investment amount is low, the business is already doing everything that an E-2 business needs to do in order to employ US workers. And always remember that that's the ultimate goal of an E-2 visa. The reason the E-2 visa exists is as a way for foreign nationals to build a business in the US that employs US workers. So if you can show we're already doing that, or we're clearly taking steps in that direction, the overall investment amount becomes less important. And you see that in these two examples. You have example one, someone opening a business, the investment amount's low. They've already hired 2 employees, they have good revenue, and they have 10 clients. That's not a weak case. Example 2 is a weak case, low investment amount, but they don't want to invest anything more before they get to the US. They want to wait to hire people. That's a risky case. A consular officer is going to have to make a few leaps to assume that this is a business that will actually employ US workers. And if you have a startup, how do you show the likelihood of employing US workers? A business plan. A business plan can be really key at convincing an officer that, even though we don't have tax returns, even though we don't have payroll records or bank statements that show that we're generating revenue and employing workers, we do have a solid plan to show you our marketing plan, our projected sales, our revenue, who we're going to hire each year over the next 5 years, and how by the next time you see us for our renewal, we will be employing US workers. A business plan is really the best place to do that. So let's see, unless there were any questions, GA, I'll keep going on the E-2 visa expenditures.
Yeah, let's do that.
Okay, so on the screen, you see a bunch of E-2 visa expenditures. These are common expenditures. We would consider these good expenditures. When I mentioned the spreadsheet before that we include in our applications, these are things that you would probably see on the spreadsheet. So again, we'll send this presentation to you all afterward. So no need to write it down right now, but as you are planning your E-2 visa application, maybe create your own spreadsheet and see what you've spent in each of these categories. And if you haven't spent in one of these categories, the next question is, do you need to? So licensing fees. If you're starting, a consulting firm, you may not need any licenses. If you're starting a restaurant, you probably do need some kind of permit from the Department of Health. So, that's a good checklist for you to make sure you're covering everything that you need to purchase. So what are some bad or weak expenditures? In general, these are expenditures that do not clearly contribute to the establishment or the growth of the business. As an example, many people travel to the US before they get their visa, say in B1 status, to kind of meet with colleagues, maybe meet with potential suppliers, maybe sign an office lease. All of those things are fine to do on a B1 visa. Don't include in the investment schedule in your spreadsheet the cost of the flights. Don't include lodging, don't include food, don't include fees to entertain these people. All of these things, you know, they don't clearly contribute to the growth of the business. It's not clear, you know, that they're beneficial to the business. And you really just want to avoid raising any additional questions by the government official. You know, you want them to see a list where every single thing they see on that list, again, if we go to the list of good expenditures, makes sense. For example, of course, you need office furniture. Great, you bought some chairs. Great, you bought laptops. Of course, you need laptops for the functioning of your business. You need inventory if you're selling things. You need a website. All of these things, no consular officer is going to say, well, you know, I don't think you need a website. I don't think you need furniture. Now, within reason, right? You're not going to have an investment amount of $100,000 and have spent $90,000 on nice office furniture. But within reason, all of these things are things that will make sense to the officer. The items here on the bad expenditure list are things that the officer is going to say, first of all, how is this really related to your business? And second of all, what is it saying that you would include these on the list? Are you trying to compensate for the lack of valid expenses? Are you trying to distract the officer's attention from actual good expenditures? So best to just leave these off. It's fine if you spend money on them. It's fine if you travel to the US, just don't present them to the consular officer as, you know, satisfying the investment amount.
All right, thanks, Dustin. So before we move on to the next slide, then maybe we can answer one question about the timing of investments. So there is a question that came up in the Q&A box. Someone has been already running the business, and I'm assuming with work authorization. Can somebody count the investment made over the year as they were building up the business, or can somebody only count the initial investment in the beginning?
That's a great question. So the answer is not a simple one, but in general, if the expenditure was directly related to the business and you still have documentation, so an invoice, a bank statement showing proof that you paid for it, then the answer is yes, the expenditure can be included. Now, things to be careful of. You always want to frame the investment amount within the valid source of funds. So let's say that you are claiming that your source of funds for your E-2 business is that you sold an apartment that you own, and you sold that apartment 3 months ago. In that case, you would not be able to include expenditures from the year before, because obviously the source of funds was triggered 3 months ago. So chronologically, you want it to make sense. In that case, you would just need to point to another source of funds that occurred before the expenditures that you're asking about. And you'd need documentation of those. So that income. So as long as you can document the source of those funds, and you have documentation that you actually did spend that money and it's directly related to the business, in general, yes, you can use those expenses.
Great.
Perfect. So we'll now shift gears a bit and look at two broad categories of E-2 businesses that tend to raise flags. Both of these categories of businesses really get at a few of the E-2 requirements that we talked about before. The first being real and operating. The second being the marginality requirement. So as you'll see, both of these types of businesses, there are real questions about whether, oh, and the final requirement is the develop and direct requirement. So really what you're going to see in these two categories being actually, let me skip this slide real quick. I'm referring to real estate investments and equity trading. So in these two categories, real estate investments and then equity and trading companies, you're going to see problems with the business being real and operating, because the issue is that it may be passive. You're going to see real questions about whether the business is likely to employ US workers. And finally, you're going to see issues with the develop and direct requirement. Is this a business where the owner is actually actively engaged in developing and directing the business? So real estate investment companies, big red flag for the government. It does seem that government officers are trained to flag these types of businesses, and the default is deny unless you are convinced that they are truly an E-2 qualified business. So what do we mean by real estate investment businesses? It really is a business that owns real estate and aims to generate profit by that real estate appreciating in value. That kind of a business does not clearly require US workers. You could easily establish an LLC that owns, land, and that just holds that land. You could spend millions on the land and just hold it. Once it appreciates in value, you sell it, you buy more land. That's not going to satisfy the E-2 visa requirements, because it's not clear that there are workers required for it. It's not clear that the E-2 applicant is going to be actively doing this on a daily basis. So what do you need to do to overcome that? You need to show that your business actually does require workers, and that your business actually does require the active engagement of the E-2 investor to develop and direct it. So a real estate brokerage firm could satisfy the E-2 requirements. A real estate management company where you do have employees that are actually visiting apartments, fixing them, cleaning them, maintaining them, that you as the E-2 investor are advertising your business. Same is true for real estate renovation and construction companies. Again, you may have valid employees. You may need to market this and really do everything that's required for a normal, non-passive company. House flipping tends to be tricky because house flipping, you really do need to show that you're doing it at scale, at a sufficient scale to employ US workers. And again, for any of these categories, it's especially important that you show in your application that either you already employ US workers or that you have a very clear plan for employing US workers, and you have clear job duties as the E-2 investor to develop and direct the business. Much of what I just said is also true for equity trading companies. Again, the issue with these is that the government assumes that they are passive unless you show them otherwise. So placing stock in a stock portfolio in an LLC in the hopes that it will appreciate, not clearly an active business, right? You don't need to look at that investment portfolio every day or even every month in order for it to, exist and to succeed. If you're going to do an equity trading company, it's important to show the government that you really have marketed the company and you've marketed it outside of friends and family, that this really is going to take in, funds from a broad swath of people. You don't necessarily need a lot of people, but it needs to be clear that this is not a family or, a very closely held business. You also need to show that you have all of the required licenses and approvals from the government. These businesses tend to be very highly regulated. So those are some flags. These are, again, just companies that the government assumes are passive. So an application really needs to go in strong, making clear not only are these businesses, is your business, if you're in one of these two areas, not passive, but you're already employing US workers, ideally. Let's go back to consulting businesses. I skipped this slide before. So we've touched on a number of the bullets that are on the slide because consulting businesses, this is just an example of a business that doesn't necessarily need a lot of funding to get started. And I think the issue here is, and again, these are cases that we actually manage quite frequently. Consulting businesses, again, you need to take certain steps that make it clear that even though your business does not require a lot of overhead or a lot of startup investment, you really have taken the steps that satisfy the E-2 requirements. So, I would always say it's not necessary to throw money at a business if it actually doesn't benefit it. So if you're starting a consulting company and it takes $50,000 to purchase all of the things on that spreadsheet we talked about, office space, everything, your laptop, your phones, utilities, everything's purchased. You spent $50,000, you have a website, and you really are struggling to think of what else you could spend money on. Don't just throw money out the window. First of all, think about what you might invest in that actually does benefit the business. Oftentimes, there are opportunities to invest more in marketing. So that could be a good opportunity to spend more money, to increase, Facebook ads, to increase your SEO results on Google, to create a nicer website, whatever kind of marketing, to buy ads, things like this, could be a very valid way to spend more money that actually does help the business. Second of all, think about hiring an employee. Even if you're not ready for a full-time employee, I see the question in the question and answer box. Can you hire contractors? Yes, you can hire a contractor or have a contractor. You can have a part-time worker. Something is better than nothing in these applications. And so, maybe it's even just someone who's remote and part-time who just, develops your website or maintains your website. Or maybe it's someone that answers the phone or helps to organize your materials, your emails, your meetings. All of these people, these roles can count and justifiably add to your investment amount. So first, think about ways that you might spend more on the business creatively, but in a way that benefits the business. You also want to take any steps that, again, similar to the real estate and equity businesses we talked about before, that show that the business is real and operating. So show that you have interest in your consulting business. Show that you have letters of intent to do business, that you've signed contracts with clients or with suppliers. Show that you have an active website, of course. Anything that shows that you really are starting to take steps toward making this a fully functioning business and hiring workers is important. A helpful way to frame this is to think about what the consular officer would think. If let's say you have a friend who comes to you and says, I'm going to start a business in the United States. And this is a friend who, they're not your best friend. You don't know them all that well. And you're not really sure how serious they are about this. What are the things that you would want to hear from them that would convince you that, wow, this person is actually really serious about going to the US and starting a business? If they tell you, yeah, I've moved, $100,000 into a business bank account, you're probably not going to be that convinced. They can always move that money out. It's not that convincing. But if they say, I've spent $100,000, I actually rented an office, we have a website, I've started advertising, I even hired someone in the US who's helping me, with my administrative tasks, you're going to start thinking, this person's actually really serious about this. A consular officer is a human. They're no different from you and me. And so they also are convinced by these things. So the more you can show them that you're serious about this and you've taken steps to really get your consulting business running, even though the investment amount is low, the better. And one final thing, another way that you can increase your investment amount is actually by paying your office rent in advance. You can only include in your investment schedule, meaning, when you show the government your investment amount, all you can count is money that's actually been spent. So let's say that you have an office lease where you're committed to pay rent for a year, but you've only paid 2 months rent. You can only include the 2 months rent that you've actually paid. But you can go to the landlord and you can say, I want to pay 6 months in advance. Pay that 6 months. You can include the full amount in your investment schedule. So that can be a great way to increase your investment amount. I'll pause there, GA, in case there are any questions.
Yeah, so the only outstanding question related to that regarding the consultancies is, being the sole employee at the beginning. And I think we already sort of answered this question where it is preferable definitely to have employees as early as possible.
It is, yeah, it's preferable to have employees as early as possible. If you are the sole employee of your business and it just doesn't make sense to hire anyone, I would say two things. First of all, consider applying at a consulate. Again, USCIS tends to be far stricter in terms of having employees. They do not want the E-2 applicant to be the one delivering services, USCIS. So it might benefit you to apply at a consulate. The other thing, I didn't say this before, but it is important to know, USCIS also, one of the benefits of applying at USCIS is they tend to be less strict about the investment amount. So if you have a lower investment amount, you might consider applying for a change of status from within the US rather than at a consulate. And consulates do vary. Some consulates want to see $100,000, $150,000, and they won't approve an application below that amount. Other consulates are much more open to low investment amounts, and we do help our clients navigate that. It can be an important part of the strategy. But yes, if you're the sole employee, it can work. We have plenty of E-2 applications approved where, it's just the owner working there at the start. I would say, first of all, show in your business plan that you're going to hire someone soon, ideally within the first 2 years. And definitely you want to show you have at least 3 full-time equivalent employees within 5 years. But that can work. All right, so common reasons for E-2 denials. We've talked about low investment amount a lot. The nature of the business we've also talked about. There are certain businesses that the government just scrutinizes and is just skeptical about. Real estate investment companies and equity trading companies are just 2 examples. The location or venue where you apply, we talked about that as well. Certain consulates are just stricter than others. Another reason for E-2 denials is if the applicant has a similar business in their home country that has not been successful. If you are applying to start a consulting firm in the US and you already have a consulting firm in Germany, but that's been active for 5 years, but you haven't employed anyone at that consulting firm over the course of those 5 years, that is a hurdle you have to overcome. You need to go to your consular interview ready to explain how your US business is going to be different. And it really does need to be a material difference. You're selling something different. You are taking a completely different approach. Something needs to be different so that the officer is convinced that this time you will employ people. But it is a negative if you have a similar business abroad that has not employed workers. Similarly, if you're buying a business in the US, you want to make sure you're buying a business that ideally already has at least 3 workers. If you're buying a business that has been functional for a few years and it doesn't have workers, you have some explaining to do. You have to convince the government that there's something you're going to do that's going to result in employees being hired. Sometimes there are simply issues with the adjudicating officer. Officers sometimes just don't either understand the law or they are in a bad mood. They have complete discretion on these applications, unfortunately. More often than not, officers are reasonable and they do know the requirements. So usually this isn't an issue, but you may get a bad officer, frankly, and that does happen. And there's honestly not a lot to do about it after the denial, except you can always apply again. So, and if you apply again, oftentimes the consulate will try to give your application to a different officer. So, people do come to us after they have applied outside with another firm or on their own and have received a denial. It is not uncommon for them to be approved after that. We'll look at their application, see how to improve it, and then resubmit the application, and frequently it will be approved. And sometimes the applicant simply did not meet the E-2 visa requirements at the time of filing. If you haven't invested a sufficient amount, a substantial amount, you may be denied. If you don't have the treaty country nationality, if you don't own 50%, you're probably going to be denied outright, or you should be. And sometimes people come to us after a denial and we look at the application and tell them that, there are certain aspects you really do need to change because this is not an approvable application as you submitted it. So sometimes that is the issue. I just realized we are over time. So I will try to get through the remaining slides efficiently. Adjudication trends, consulates are still backlogged due to COVID. They are definitely getting better in our experience and working through those backlogs, which is great. USCIS, if you're in the US, still is an option. You can premium process. You'll get a decision in 2 weeks. It does cost $2,500. That you pay to the government for them to expedite your application. But if you're in the US, that could be a good option while you're waiting for a consulate.
Related to
yeah.
that, Dustin, so we do have a question: how long usually does the visa take to be approved? And so for USCIS, you just said premium processing will get you an answer within 15 days. What about the consular option in recent months?
Yeah, it really depends on the consulate. I would say assume something in the realm of 4 to 6 months, but if you are working with an attorney, they should be aware of where consulates are. And we could give you a much better sense if you want to schedule a consultation. But 4 to 6 months is a good estimate. Some consulates are faster, as fast as a month or two. Some consulates are far longer, a year or more is what I see at the higher end. And USCIS, if you don't do premium processing, they will take a few months. They'll take usually 6 months in that realm, but you can check USCIS processing times. If you Google that, they will give you an estimate. Excuse me. And the form is the I-129 that you want to check. All right. We talked about a number of these. You do not have to hire employees before you apply, but you should show that you have a plan to very soon after you're approved. Complicated source and trail of funds. You do need to document where you got the money from, especially if you're applying with USCIS. Consulates tend to spend less time on the source of the funds. Loans are okay, gifts are okay. Loans cannot be secured by the E-2 business or its assets. Gifts, you need to show where the person who gave you the gift got the money. So if it's a parent and they worked for 2 decades and saved up, you do need to show their tax returns. Be prepared to show their tax returns and their bank statements showing the accumulation of funds, especially if you're applying at USCIS. The business might change after you apply. If the business is still similar to the one that you applied for, so let's say you're starting a restaurant and you open a little coffee shop, that's probably fine. You probably don't need approval. But if you start a business and you want to start a consulting company on the side, you do need to seek government approval for that, either at the consulate or USCIS. We can help with that. They can be complicated requests, so do schedule a consultation. Also, if that's your plan, frame the business broadly in your initial application. Make the business plan broader. Say, I want to start a restaurant, but I also want to consult on the side. Present it in the business plan. If it's approved, that's the scope of your business, so you're set. Family business purchases. Be very careful if you are purchasing a business from a family member, because the government is going to think that, or going to suspect that the funds did not actually leave your pocket. They're going to want to see documentation that you actually did spend the money, that it was a legitimate business purchase. So if you do this, make sure you have documentation to back up the transaction. All right, I think we can take a minute to see if there were any other questions, GA, and then I should let everyone go because I'm late. late on this presentation. I just realized we're 10 minutes over.
Very helpful though, because we did have a lot of questions and we did answer a lot of them. So I'm sure this has been super helpful for everybody. So one question we can talk about maybe is, if the visa is denied, can it be filed again?
It can be, yes.
Yes, it can. And so what about the source of funds? Can it be a gift? And I believe the answer is yes. And can it be a gift from someone in the USA?
It can be, yes. You would just need to document where the money came from, where they got the money.
And there is another final question about the investment amount. And someone is considering the possibility of investing with a partner to double the project money, or doing it by themselves. But how would this affect the substantial investment requirement?
I would say that you have to look at the business. So if you're starting a business that if it's just you just don't have the money to fully fund it, then you should consider going in with a partner so you can show the government that the business is fully funded. But if you alone are able to invest a sufficient amount to get the business started, that could be fine. It's not necessarily better to bring in a partner with more money unless that's necessary for the business to actually be operational.
All right. Well, I think that is pretty much all of the questions that we had. Dustin, thank you so much for your time. This has been incredibly helpful. And for everyone who has participated, please do feel free to schedule a consultation with us to discuss your case further. We have a volume of experience in E-2 visas, in particular with risky cases, and we will be happy to help you with your case.
Thank you so much, everyone. Thank you, GA.
Thank you.